So in order to consider the relationship between the law of euthanasia, or death and dying, and ethical debates, we need to have a sense of what the fundamental principles of law are. And one of the things you need to remember is that they're not really designed to deal with the euthanasia question. So if we think about ethical distinctions that matter in the debate about euthanasia, one of those will be the question of the amount of choice that a patient has and a professional has over what happens. And you'll sometimes see people talking about the difference between voluntary euthanasia, where choices are made by the patients, involuntary euthanasia, where the decision about whether a life is worth living seems to be made by the health professionals. And sometimes you'll also see discussion of an intermediate category, a non-voluntary category, where it isn't against the wishes of the patient, but nor has the patient made a choice. And that may be particularly important in relation to cases where patients are incapable of choosing, perhaps in the advanced stages of dementia or in a coma. So one set of ethical principles relates to the degree of choice. A second ethical issue that you will have been discussing relates to the difference between taking active steps to end a life and standing by when it might be possible to prolong a life. Sometimes talked about in terms of the difference between active euthanasia or killing, and some people say that's the only proper use of the phrase euthanasia, or passive euthanasia, allowing people to die. Now those distinctions do sort of map onto legal tests, but they don't do so neatly, and they do so largely by accident rather than design, and that pulls attention to one of the differences between ethical and legal reasoning. They do different jobs and they work against different sets of principles. So I want just to outline some basic principles of the English law relating to end-of-life care. Each legal system will have its distinct rules. They'll all deal with these sorts of questions, but you can't assume that they will be the same in different countries. And that again raises an interesting question about the connection between law and ethics. To what extent is law nation-specific and local? And to what extent does that differ from the idea that ethics claim to a degree of universalism and fundamental principles that should hold in all places and perhaps over time, depending on the nature of your approach to ethics? So in English law, the first fundamental principle is that the choice of treatment to select, to be offered to patients, is governed by the law relating to proper professional practice. So patients are not entitled to have care just because they want it. Health professionals have to assess whether the care is clinically appropriate. And the law measures that essentially against the standards of good professional practice that are used outside of the end-of-life care context. In England, that's essentially a peer review standard. Clinicians are expected to behave in a way that responsible practice expects of them. To suggest that care should have been given when the clinician doesn't think is appropriate, or that care shouldn't have been withdrawn when the clinician thinks it was appropriate to withdraw it, is going to be a question of whether or not that clinician has acted in a way that's recognised as responsible by professional peers. In English law, that's sometimes described as the Bolam test. And that means that patients have very little choice over what happens. They or their family may be able to challenge decisions that are made and get some degree of court oversight, but the court will be asking itself whether or not the decision to offer treatment or not offer treatment was responsibly made. They've also established that there's a duty to consult, so those decisions in relation to end-of-life care, life and death questions shouldn't be made without the family and the patient knowing that they're being considered and having the opportunity to make representations. But fundamentally, the background legal test is that clinicians can't be expected to offer care that is not professionally appropriate. And the courts have protected that discretion against claims from patients that they should be entitled to have their lives prolonged, even if it's not clinically appropriate, as well as cases where they want to have care withdrawn. So you might argue that that allows within English law involuntary, against the wishes of the patient, passive euthanasia. but it's not a set of rules designed to deal with end-of-life care. It's a set of rules designed to deal with clinical decision-making generally. The second key structure of English healthcare law is that once you've resolved whether or not as a clinician that it's appropriate to offer care, it's up to the patient whether she or he accepts the care that you have on offer. So this is the law relating to consent, or more specifically the right to refuse care that's offered to you that you don't want, provided always that you're competent to make that decision. You understand the nature and purpose of the treatment, and you can weigh up the pros and cons in the balance and take a view as to what you think is appropriate. And patients are entitled to refuse care even if that refusal is going to lead to the shortening of their lives. So you might argue then that this allows voluntary passive euthanasia, the right to refuse care that will keep you alive. So insofar as you're being kept alive by the doctor, you have the right to die, you have the right to refuse that care. But because of the first principle, that care that should be offered is only care that's professionally appropriate, you don't have the right to active euthanasia, the right to choose the death when you want it. If there's a dispute about whether or not someone is competent, then there's a process for assessing competence under our capacity legislation, and we have the opportunity to go to court and have the court review the question of competence. But even if the court reviews the competence, it will lead to the decision who's having the choice. And if the court thinks that the patient is competent, the court won't go on to decide whether or not the patient is making a wise decision. She's entitled to refuse treatment, even if the court thinks that's a strange or silly thing for her to do. So then we move to a third principle, which is the principle that prohibits active steps that end someone's life. This is not a particular principle around healthcare. This is the law relating to murder, that you can't kill people and therefore you can't kill your patients. The only extent to which that's softened in relation to healthcare practice relates to the difficult decisions that are made about end-of-life care, where a decision might incidentally shorten life but isn't intended to. And English law has developed a principle that started in a case in the 1950s where a doctor was accused of ending the lives of his elderly patients in order, some thought, to get some financial benefits, others perhaps just because it was the power he exercised over them, and he was acquitted. And the law has been extrapolated from the direction to the jury that was given, a case called Crown against Adams in 1957. And that direction to the jury asked the jury to consider, first of all, whether or not the act shortened life, because the patient was not so near to death that you couldn't really say that the act was the cause of death, that the underlying cause of death was the illness. So there's a requirement that the patient should be close to death. Secondly, that the care being given, even though it might incidentally have shortened life, had to be responsible professional care. So even if the doctor was aware that there might be some shortening of life, it was still good medical care. Then the jury was invited to acquit. And thirdly, the judge suggested to the jury that they had to be satisfied that there was no improper motive, that the doctor wasn't doing it for some non-medical reason to inherit or to make their lives more convenient, but was given for a proper medical reason, such as to control or reduce pain. Now in the case, Dr. Bodkin Adams, who was being prosecuted, was acquitted, but we don't really have that much information about how that might apply in the future. What we do know is those three tests have subsequently received the support from the highest court in the land, then the House of Lords, and are relied upon as being a guide to what a doctor can plead in her defence, which in philosophical terms is probably a version of the doctrine of double effect, but it doesn't work neatly and precisely and philosophically carefully in the way that philosophers would talk about that doctrine. It's almost more like an oblique intention, the intention to pursue one objective, knowing that there will be elements of that that will be unsatisfactory, but the primary motive is dealt with as if it's the only motive. And these are not rules that work very well more broadly in the law. So we don't usually think the fact that someone believes their cause is just is a justification for disobeying the law. That's the issue in relation to terrorism. We don't usually believe that just because a group of people think that their way of doing things is better than society's way of doing things, that makes it acceptable. And yet under the Bodkin-Adams approach, it seems that provided doctors think this is the right way to do, they're given some form of exemption from the usual restrictions on shortening life. And thirdly, we don't usually think that it makes any difference to someone's culpability about shortening lives if someone is about to die from some other cause. So we don't think it's okay to shoot someone who's about to be run over by a bus. We still think that's wrong, even though had you not shot them, they might have died from some other cause. We still hold someone to account for the decision they make to end that life. So the rules that are set out in the Adams case and which apply to those choices around end-of-life care, which incidentally might shorten life, are rules that don't sit very easily with English law, but they seem to have been put in place to adapt to some of the challenges of end-of-life care. But they've had to work within the odd processes of English law built out of specific cases and then extrapolated into general principles, not because there's been some careful debate about the best distinctions to make between the type of shortening of life which is good medical practice and the type that is not, that you would debate if you were looking at this from a philosophical perspective. There's a degree of accident about the way in which the legal principles develop. And that's also true of the final area that we need to think about, which is the law under the Suicide Act of 1961, although that was amended in 2009. And that law is used now to discuss questions that if we were having a broader policy debate in bioethics, we would probably talk about under the heading of physician-assisted suicide. And there have been a series of cases before the top courts, including the European Court of Human Rights, as well as the House of Lords and what's replaced it, the Supreme Court in the United Kingdom, which have explored the extent to which the Suicide Act, which legalised attempted suicide, but introduced an offence, a specific offence of assisting or encouraging suicide. How does that work in the context of end-of-life care and the sorts of decisions that are thought about it under the rubric of euthanasia? And we've seen litigation, test case litigation, trying to change the legal provisions being taken through the courts. The first of the important recent cases was the case of Diane Pretty, and that established in front of the European Court of Human Rights that there was a human rights issue at stake, that people had right to respect for their private and family life, and that included autonomy over their care at the end of life. But the European Court of Human Rights found that the UK law could legitimately restrict that right, even though that right needed to be taken into account, in order to protect the rights and freedoms of others, which they understood to be vulnerable people who might be worried or at risk of abuse at the end of their lives if there wasn't a rigid and blanket prohibition on helping people die. Physician-assisted suicide is one example of that, but it's not limited to the medical context, so it's not really a medical law case. And the only recent successful prosecution has not been a medical law case, it's been a case where someone poured inflammable material over someone and set them alight, really outside the scope of due medical care. But we've since then seen a number of attempts to chip away at the acceptance of the European Court of Human Rights of that prohibition on assistance in dying. So in the Purdy case in 2009, the argument was made that even if you could balance the right to decide whether or not you wanted to carry on your life and how you wanted to end your life against the rights and freedoms of others who might be vulnerable, you could only do that if the law was precise and people could plan the way in which they were going to live, and it was argued that English law was too vague. I happen to think that was a very poor decision. I don't think English law was vague. It was clear that the actions that were talked about in that case were going to be in breach of the Suicide Act. But the difficulty came that there were relatively few prosecutions for breaching those rules, and the argument that Debbie Purdy made, and which the House of Lords accepted, was an argument that the fact that not all cases seemed to get prosecuted brought the law into disuse, and that made it vague. And they required the Director of Public Prosecutions to issue a code of practice explaining how decisions whether or not to prosecute would be made. And that went through a consultation process, and we now have a set of guidelines which explain a whole set of factors that should be taken into account in deciding whether or not it's in the public interest to prosecute people who, for compassionate reasons, typically end the life at the request of someone else. And there have been a number of cases that have been referred to the Director of Public Prosecutions, but no cases of conviction in the medical context where the assessment made was that the medical treatment was the appropriate treatment. And then we've seen more litigation. The UK Supreme Court, in a case called Nicklinson in 2014, argued that Parliament needed to look at the question again, because the balancing between the rights and freedoms of others and the rights of people to choose how they ended their lives might not have been properly struck. And they challenged Parliament to have a look at that, indicating that they felt there was a human rights issue there. And although that was probably best resolved in Parliament, they reserved the right to take the view that Parliament had not properly respected the human rights of the people who were dying. And that's sort of working its way through the courts at the moment. In the most recent decision, known as Conway, and decided in 2018, there was this recognition that, as well as the rights of vulnerable people, it was also reasonable for the law to protect trust in the doctor-patient relationship, and also to think that there was a fundamental need to respect the sanctity of life, which might justify restricting the freedoms that people have to choose. So we have a little bit of a constitutional standoff at the moment about who's going to drive this forward, the courts or Parliament. But Parliament has declined so far to change the law, and the latest set of decisions recognise that this was a matter of judgment that was probably more appropriate to be taken democratically in Parliament than it was to be litigated in the courts. We don't know quite how far that will stick. The Supreme Court has also indicated in 2018 that in relation to abortion, it does see the opportunity to take a position and say sometimes Parliament doesn't get the balancing of rights correctly, and we will need to see how that plays out. But currently the Court of Appeal seems to be suggesting a bit of caution in relation to end-of-life care. So that leaves us with a position whereby physician-assisted suicide is not acceptable in English law, but it's not acceptable not because someone has sat down and designed a set of rules on physician-assisted suicide, but because we set up a rule to protect vulnerable people contemplating suicide from being pressurised by third parties. We then sought to adapt how that applies in the medical context, and we've identified some reasons that might make us more sympathetic to the idea this is the lesser of the evils, and we've relied on the Director of Prosecutions to, if you like, exercise the prerogative of mercy while holding a pretty strict rule that it's something that is outside the scope of legally permitted actions. So it might be a crime that is not prosecuted, but it remains very clear in English law that this is a crime. Whether you think those reflect good ethics, they've certainly been arrived at largely by a system of legal accidents. And it's by no means clear that we would have reached the same position if we had sat down, had a careful parliamentary debate with preparatory work from a commission. Instead, we have a degree of tactics. The activists on both sides have taken advantage of whatever opportunities were there. And there is a cynical view that's been expressed that The latest rejection by Parliament of any liberalisation on the law relating to assisted suicide is as much a result of the accident of that vote having started in the House of Commons rather than the House of Lords. The House of Lords seemed to have been moving gradually towards more sympathy to changing the law. But the vote came before it came in the House of Lords, the vote came in the House of Commons. They hadn't been subject to the same lobbying, and they were persuaded more by the problems than they were by the moral arguments about freedom to choose and liberty at the end of life. Now, you will have your own views on whether or not the law is consistent with good ethics, but the important point is that it hasn't been produced by a process that is designed to ask about ethical questions. It's been produced by a process that's trying to adapt rules of English law designed for other purposes and to apply them in the context of end-of-life care. So to that extent, whether there is a strong argument for simply obeying the law and taking it at face value seems to be as much a matter of historical accident as it is good ethical reasoning.